Thank you, Mr. Speaker. And Mr. Speaker, it's a privilege to present. It was a privilege to present Bill C-20, the Fairness to Victims of Violent Offenders Act, the House back in February. And it's a privilege today, although it's with mixed emotions, to be the first to speak on second reading. I'd like to use my time today to reinforce the reasons why this bill will help recalibrate the balance between the rights of violent offenders and the rights of their victims. But first, and most importantly, I'd like to share with the House why I worked to bring this bill forward. Like many honourable members, I've received calls from constituents over the years expressing concern that our system, in their opinion, seems to give more weight to the rights of those convicted of very serious and very heinous crimes rather than the victims of those very same crimes. Story after story I heard regarding the emotional trauma of victims and their feelings of being re-victimized by a system they feel more favors the guilty. However, nothing could have made me realize more their pain and their trauma than this experience I had last May when I visited a parole board hearing. At the request of a constituent, I attended the National Parole Board to listen, to learn, and observe about the process. The case was one of direct relevance to my constituent as well, of course, to myself because of the local nature of it. Her sister and her sister's two children had been killed years ago by a murderer who was once again up for parole. I don't think anything could have prepared me for what I was about to experience. The violent offender and the family of the woman and children he killed shared the same hearing room for 4 hours. The raw emotion in the room was unspeakable. To this day, it's hard to find the words to actually do justice to that experience. Exacerbating the situation, this triple murderer still refused to take responsibility for his crime. No real remorse was shown, and still to this day has not taken any responsibility. As a result, thankfully, his parole was denied. Again. Mr. Speaker, can you imagine? I'd like to read something from a publication called The Record, print media, and it's about the actual experience I had, and they're reporting on what the victim experienced. She said this: Janice told the hearing, "This horrible crime committed by John Rollo still affects me every single day. I know it will continue to do so in the future. The fact that John Rollo has never acknowledged his horrific deeds and has never revealed Jason's resting place only makes the burden more difficult to bear." Yes, he didn't even have the graciousness enough to say where he dumped one of the bodies, and they still don't know where Jason's body is. Even when I think of it now, it strengthens my resolve to bring this bill to fruition despite the circumstances we find ourselves in the House today. Throughout this process of considering this bill, I consulted with victims groups, prosecutors, defense attorneys, police officers, and many groups to come up with a realistic and workable bill that would be supportable for all members in this House. Mr. Speaker, the Sampson Report, named after former Ontario Minister of Corrections Rob Sampson, was entitled A Roadmap to Strengthen Public Safety. It included 109 recommendations on improvements to corrections and public safety when it was released in December 2007, and it was a good resource in the development of this bill. The report cited the changing offender profile, and here are a couple of points from the report. Nearly 60% of our inmates are now serving sentences of less than 3 years and have histories of violence. 1 in 6 now have known gang and or organized crime affiliations. Also in 2007, the Office of the Federal Ombudsman for Victims of Crime was established. They have been advocates for victims across the country, raising awareness and making recommendations for change. Let me give you just one small fact, but one with a big impact. When testifying before the Standing Senate Committee on Legal and Constitutional Affairs on March 3, 2011, Sue O'Sullivan, the Federal Ombudsman for Victims of Crime, in quoting a Department of Justice report, said the following: "Victims pay 67% of the costs of crime." 67% of the costs of crime. That's an alarming statistic, and it illustrates very clearly another reason why fairness for victims needs to be addressed. And let me be clear so there's no misconception on the outset, Mr. Speaker. The reforms we're talking about here to give greater voice and choice to victims cannot be quickly dismissed as simply following some kind of American model or something. Our Commonwealth colleagues like Australia, New Zealand, and the United Kingdom have also enacted some of these very same changes. While not everything can be accomplished in one bill, my hope is that Fairness for Victims of Violent Offenders Act builds on the work of our government's Tough on Crime agenda. These reports and of the advocates that have been championing victims' rights in Canada for decades. So, Mr. Speaker, what specifically does this bill do? In the simplest of terms, it amends the Corrections and Conditional Release Act in two important ways. One, it gives greater voice and choice to victims. And number two, it gives the National Parole Board more discretion in how they review the cases of violent offenders, lengthening the time that the National Parole Board has for mandatory review of sentences for offenses involving violence. What does this include? This includes ensuring the victim's rights to present a victim impact statement is enshrined in law, so that the National Parole Board must consider it part of the hearing. It's simply a matter of fairness. Now, Mr. Speaker, I have not heard of a case to date when a victim was deprived of the right by the National Parole Board to present an impact statement. Nevertheless, enshrining the right to present a victim impact statement in legislation clearly establishes its importance to all Canadians. As I included each provision in my bill, I thought back to the Parole Board hearing I witnessed in the spring of 2010 and asked myself, will this make it fairer? Will this help ease the burden on victims, help ease the burden on victims' families? What's more is that the bill also includes recognition that technology has advanced since the last time the Corrections and Conditional Release Act was reviewed. As a result, this bill amends the Act to ensure that in the event a victim cannot or chooses not to attend a parole hearing, they're allowed to use any commonly available form of audio or video format to make the statement. This is entirely in addition, of course, to the written statement as well, Mr. Speaker. It gives victims and families an option to not have to relive the pain at a hearing if the person so chooses. Given the proliferation of digital and video formats available today and the speed in which technology advances, this again only makes common sense. So again, Mr. Speaker, I thought back to that experience in May 2010 and asked myself, will this law make it more fair? Will it restore balance? Will it help ease the burden, again, on victims and on their families? Another point, Mr. Speaker, this bill, the Fairness of Victims of Violent Offenders Act, also increases the period within which the National Parole Board must provide a further review of parole in the case of offenders serving a sentence for an offence involving violence. It would increase the review period from within 4 years from the current within 2 years. Let me repeat that for clarification, Mr. Speaker. It would increase the period 4 years rather than from the current 2 years. And there's more. In the cases of statutory release, where offenders cause death or serious violent harm to another, it would increase double the review period to 2 years from the current 1 year. The net effect is to give more necessary latitude to the National Parole Board in dealing with cases of violent offenders. And at this point, Mr. Speaker, I wanted to read another excerpt from a piece of media, again another experience of victims, this time victims of Clifford Olson, and this was printed in the province in 2010. Olson, 70, who seems to take pleasure in re-victimizing the families of those he killed, is automatically eligible for parole every 2 years until the day he dies. Ray King, whose only son was 15 when Olson killed him, plans to be at the parole hearing but said it's difficult facing the prospect of hearing this thing every 2 years. Of course it's hard, he said. It's hard just hearing Olson's name. King said he'd like to see the rules changed to prevent killers from having regular parole hearings. I'd like to be able to fly, but that's not going to happen either. There's nothing that can be done until he's dead. I'd be glad if he died. Sharon Rosenfeld, whose 16-year-old son Darren was murdered by Olson in April 1981, said from Montreal that she and her daughter will attend Olson's hearing. I'll be attending parole hearings until Clifford Olson dies or I die, said Rosenfeld, who attended the last hearing with her daughter in Montreal area prison in July 2006. But it's always been really unsettling to us. When Clifford Olson was first sentenced, I thought it would be for life. Well, he's been part of our lives for coming up to 30 years. It will be 30 years in April that Darren went missing and was murdered. To have to relive this thing every 2 years is so inhumane. It really is. So again, Mr. Speaker, going back to my experience in May, I ask myself again, will this law make it more fair? Will it restore balance? Will it help to ease the burden of victims? Victims should have the assurance as well, Mr. Speaker, that those who have harmed them so severely have actually taken serious their responsibility to endeavor to be rehabilitated and return to society a law-abiding and contributing citizen. Finally and additionally, this bill allows victims increased access to offender documents related to the upcoming parole hearing. Again, I'll just want to read one more excerpt. I know that these are a little bit long, but they're very germane to the subject at hand, Mr. Speaker. This is about Constable Michael Sweet, no relation to me, and I'd just like to read the account. In the early hours of March 14th, 1980, brothers Craig and Jamie Monroe entered what was then George's Bourbon Street restaurant in downtown Toronto for the purpose of committing a robbery. Both men were high on drugs and armed with guns. At the time, Craig Monroe was on mandatory supervision from a penitentiary. The brothers gathered all the people inside into one place, but one of the victims managed to successfully flee. Once out on the street, he flagged down a passing police cruiser. Constable Sweet, 30, entered the restaurant and was immediately shot twice. There then began a 90-minute standoff between the Monroe brothers and the hostages and the police. The police later stormed the restaurant. Both brothers were shot and captured. During the standoff, Sweet was conscious and slowly bleeding to death. He begged his captors to let him go to the hospital because he had 3 young daughters. While Sweet pleaded for his life, they laughed and taunted him. All 3 men were later transported to the hospital. The Monroe brothers survived their injuries. Sweet didn't survive. Jamie Monroe was convicted of second-degree murder and sentenced to life imprisonment. He was granted parole in 1992, married an Italian woman, and is believed to be living in Italy. Craig Monroe, who was the one that shot Constable Sweet, was convicted of first-degree murder. He was automatically sentenced to life imprisonment with no chance of parole for 25 years. As Karen Fraser, who is the wife of the late Constable Sweet, said at the press conference, the crime against her husband took place in a public place. Craig Monroe's trial and sentencing were held in public, but the prison records that were available to Monroe and used by the parole board in deciding whether or not he should be granted parole were not available to her or any of the public because they were protected under the Privacy Act. Craig Monroe could have authorized the release of those records to the Sweet family, but he exercised his right not to do so. Again, Mr. Speaker, this is a matter of fairness. And again, I thought back to my experience of 2010 and asked myself, does this law make it more fair? Does it give the victims more voice and their families more ease of their burden? I believe the answers to all these questions that I've asked throughout my speech, Mr. Speaker, are yes. I believe this bill reaffirms what the Sampson report said, that parole release from prison is a privilege, not a right. Parole release from prison, Mr. Speaker, is a privilege, not a right. It must be earned, and that includes showing remorse for the crime and seeking rehabilitation. rehabilitation is the key. The National Parole Board must be convinced that the violent offender won't recommit. It's the least we can do to offer dignity to victims. Thank you very much, Mr. Speaker.